I'm going to talk to you about pleading guilty to a criminal offence in a Queensland Magistrates Court. When you plead guilty to a criminal offence in a Queensland Magistrates Court, this is called a sentence hearing. The judicial officer who hears your sentence hearing and decides on the penalty you receive is the magistrate. The general process of a sentence hearing in the Magistrates Court is 1. When you enter the courtroom, you or your lawyer will need to speak to the prosecutor. The prosecutor stands at the right-hand side of what's called the bar table. The bar table is positioned in the front centre of the courtroom. You'll need to tell the prosecutor your name. If you've not already told the prosecution you're intending on pleading guilty on the court date, then you'll need to tell them you want to plead guilty today. The prosecutor will make a note of this. You'll then need to take a seat in the public gallery at the back of the courtroom. Now, when your case is called on, the prosecutor will call your case on by telling the magistrate your name. The prosecutor may say something like, "Would Your Honour take the matter of your surname?" When you hear your name called out by the prosecutor, you need to go up to the front of the courtroom, stand to the far left of the bar table. If you have a lawyer, you will stand to their left at the bar table. You or your lawyer will tell the magistrate you're pleading guilty to the charge before the court. I should say, if you have a lawyer, they will do that for you. 2, the magistrate will read out the charge to you. They'll generally do this and ask you how you want to plead, that is, guilty or not guilty. The magistrate may also ask if your plea of guilty is on your own free will, and if anyone in a position of authority or anyone else has told you that you should plead guilty. Upon you entering your plea of guilty to the charge, you can then sit down on the seat to the left of your lawyer. 3, the prosecutor makes submissions. The prosecutor is the first person who gets to make submissions about the charge to the magistrate. The prosecutor may tell the court about the facts of the charge, that is, what they say you did. The facts given to the court are generally read out by the prosecutor directly from the QP9 court brief. The prosecutor may read out exactly what is written in the QP9 court brief, or they may give a summary. If you have a lot of charges, the prosecutor may hand the magistrate a document, such as a sentencing schedule or a schedule of facts, and this document will have all the information for each of the charges. They may tell the magistrate about any detail of harm caused to any victim as a consequence of the offence, details of any losses caused to any persons, and the penalty they believe the magistrate should impose. They will also tell the magistrate aggravating features of your case. Aggravating features are things about you, the victim, or the offence that may mean you should get a higher penalty. Once the prosecution has made submissions, the defence then gets to make submissions to the magistrate. If you have a lawyer, they'll do the talking for you. When a defence lawyer makes submissions for you, they'll have 2 primary aims when they make their submissions. Firstly, it's to tell the magistrate about you, your family, social background, and anything else of relevance about you as a person. Secondly, they'll attempt to persuade the magistrate to give you a particular penalty. The reason defence lawyers tell the court about you as a person is because the law says the court must have regard to your character, age, and intellectual capacity when they sentence you. Your lawyer is in the best position to inform the court about these things on your behalf. Things your lawyer may tell the magistrate may include the level of schooling you achieved, what grade you got to at school, maybe where you went to school, if you had any traumatic experiences in your life or had a traumatic upbringing, your employment history, if you've worked, your personal circumstances, your future plans, any problems you've had in your life that may have led to your offending. They may also tell the court any positive things about you that you've done in the community. If you've obtained some character references or a medical report, these will be given to the magistrate to consider when sentencing you. Your defence lawyer should discuss penalty and tell the magistrate what penalty they believe you should get. Your lawyer may or may not have precedent cases to mention to the magistrate to help them decide what penalty to give you. When I talk about a precedent case, I'm talking about cases like yours that have already been decided by the court. The outcome or decisions of these cases are sometimes published, and the decisions can be given to the magistrate to read to help them decide on the penalty to give you. Your lawyer will tell the magistrate anything in your favour that should reduce the penalty the magistrate gives you. These things are referred to as mitigating features. They may be things personal to you or the facts of the case that should cause the penalty to be reduced. Examples of mitigating features may include evidence of prospects of your rehabilitation, evidence of any remorse you've shown, having repaid the victim the loss you caused them, your offending, being for need rather than greed, your offending being a spur of the moment rather than something planned, your cooperation with the police in investigating the offence, any omissions you made to police about the offence, your previous good character if you've never committed a criminal offence before, your mental health at the time of the offence or at the time of sentence. If you're a youthful offender, being of a young age, that is. Now, when it comes time, the magistrate will pass sentence. When the prosecutor has finished and the defence have finished making submissions, the magistrate will pass sentence. When the magistrate does this, you must stand. You must listen to what the magistrate has to say. Do not interrupt the magistrate. When the magistrate is speaking, they should say things they've considered when deciding what penalty to give you. The magistrate may mention things like the facts for the offence, that is what you did, the mitigating features of your case, things in your favour, the aggravating features of your case, that is the negative things about you. And after discussing these things, the magistrate will tell you the penalty they give you.